watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Supreme Court of Florida is now in session. All we have cause to plead, draw near, give attention. You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Cmar versus the state of Florida.
May it please the court, my name is David representing Mr. Leo Cmar in this capital case. Case in which the state convicted Mr. Cmar of committing first-degree murder of his father's living girlfriend, Maria Louise, trying to sexually batter her under attempted sexual battery, and then also trying to burn the house that he, his family, or Cmar's family, Miss Louise and her, and Cmar's father and Uncle Ed lived there. This happened in Clay County, December 12th, 2008. The facts, he was convicted of that. The jury recommended death by a vote of 11-1, and the judge imposed that sentence, finding 4 aggravating factors. I've presented 9 issues to this court. Fortunately, I'm not going to be able to argue all 9, and really I'm prepared to argue 6 of them. The first, but considering the time I've got, I'd really like just to focus on the first 2, although if you have questions about any of the other remaining 6, I'll be glad to talk about that. But the first issue dealt with whether or not the state presented sufficient evidence that Cmar had in fact committed an attempted sexual battery against Maria Louise. And in presenting evidence to support that, the state showed that on December 11th, Cmar and a friend, Ryan Maudlin, in the afternoon of that day had gotten together and retreated to the back of his room where they began to smoke some marijuana and use cocaine. And by 9 o'clock at night, Cmar was, as Maudlin said, fairly high and very paranoid. About that time, Maudlin leaves. Cmar then, sometime after 11 p.m., will then go into the living room where Miss Louise was staying.
What are the ages of the victim and the...
Yeah, I really don't know. Cmar in his 30s somewhere, I would suppose. I really don't know about Miss Louise.
We don't know if the victim is younger or older. So she was the girlfriend of his father?
Right. And so we don't know in the record how old she is? There may be. I'll be honest, I can't recall what it is.
How long had they lived in the same place?
I don't recall that either, but it had been some while. She apparently lived there and felt comfortable living there, was staying in the living room.
Because his father was in prison?
His father, I think, was in the hospital at the time.
Oh, in the hospital. Somebody was in prison.
Yeah. I'm not sure who was in prison, but... I'm
just trying to get a sense of their prior relationship as it would have come out in the guilt phase to understand the dynamics in their relationship. Was there anything in the record about the nature of their relationship before the night in question?
Not that I recall. All that we know is that they lived in the same house, and that was about the extent of it.
We don't know for how long?
I don't recall how long they'd lived there, or she had lived there. Now, he had lived there with his wife and children, but on that day they were gone. The children and the wife were gone, as was routine on Friday evenings. But the defendant had, about, like I say, by 11 o'clock or so, had, with Maudlin gone, he had told Maudlin that what he wanted to do was lure Miss Louise back to the room, ply her with drugs, and hopefully could get lucky and have sex with her. Well, after Maudlin leaves, Cmar goes into the living room and begins to make passes at Miss Louise. They get in a tussle, and at some point she will go into the bathroom, lock the door. The defendant then will pound on the door, and not getting any result there, he then goes, for some reason, goes outside and knocks on the bathroom window. She doesn't respond to that, but goes into the kitchen. The defendant follows her into the kitchen.
In the tussle, are any clothes torn?
No, that's yes, I'm glad you pointed that out, because not only in that tussle in the living room, but then when they go into the kitchen, they get into sort of a tussle again. She at some point will grab a kitchen knife and point it at him. He will knock it out of her hand, hit her again, and then proceed to stab her.
You don't dispute, or do you dispute, that the reason that they got in the tussle was because he was making sexual advances towards her that became at some point unwanted.
Well, that is why he wanted that. Yeah, when he tells Maudlin.
I mean, because get lucky would mean a consensual.
Yes,
but once somebody refuses and they're basically saying no, at that point, anything that would be done sexually is unwanted.
And there was nothing done sexually. He doesn't.
Why does she have the knife?
Well, to ward him off. This is about the second time he was coming at her.
Ward him off. He wanted to shake her hand or something.
Well, no. Obviously, from what she just gone through, he was making passes at her. She didn't want them, so she
wanted to have sex.
Well, that's what he wanted to have sex, but only if he could quote get lucky, which implies some sort of consensual relationship.
I understand that, but once she's standing with a knife, doesn't it say I don't consent?
Well, that's also with the tussle. You could say the same thing.
Well, why were they tussling?
Well, because he wanted to get lucky.
All right. So
that's,
he wants something consensual, get lucky. Well, she has the knife.
He knocks it out of her hand. He doesn't. Okay. When he knocks it out of her hand, he then begins to stab her.
I got it.
But up until the point they're in the kitchen. Let's say they're in the kitchen and they're tussling back and forth. And let's say somebody walks in and stops the whole thing, and there's no murder. Up until that point, is there an attempted sexual battery?
No.
Okay, now add to that his statement later to cellmate William Valencia that once Maudlin and his girlfriend and his defendant's girlfriends left the house, that he was going to put the move on Maria Louise. If you add that to the equation, do you then have an attempted sexual battery?
Well, when you have somebody coming in and then interrupting and the knife is not a factor here. If it comes in and interrupts it, maybe that would have been an attempt.
Well, the knife is a factor. I mean that's what he would have been using to try to get her to consent to a forceful sexual battery. I'm making my position here is if you're claiming that up until the point that he stabbed her, there had been no sexual battery, which is what I think you're arguing.
Attempted sexual battery. Yes.
Attempted sexual battery.
Yes.
How do you justify that, or how do you reconcile that with his statement later to a cellmate saying that he waited for everybody to leave and he's going to put the move on her? Are you saying that would have been a consensual?
And he was hoping to get lucky. Now
that's not what he told the cellmate.
Well, that's
what he told Maudlin.
Well, that's what he told Maudlin. I mean, but the fact is, that's what he was saying. He was wanted to get her hyped up on drugs and then hopefully get lucky. And when she doesn't do that. But there was nothing that really prevented him from having sex with her.
So you're claiming.
What about her running into the bathroom and then him, beating on the door and beating on the window? I mean, that all seems to me to play into whether or not he was attempting to sexually batter her and she was resisting and ran away.
All right. First of all, Maudlin is 6'4", 290 pounds. Miss Ruiz, 5'5", 134. That man weighed twice as much as she did.
You said Maudlin?
I'm sorry, Caxmar.
Oh, okay.
I'm sorry.
That's when he tried to.
Yeah, I'm sorry.
Okay.
Caxmar is 6'4", 290 pounds. I get those names anyway, but he is certainly much bigger than Miss Ruiz. He could have plowed through that bathroom door. He doesn't. For some reason, he taps on the window. Why he does that idiotic sort of thing, I don't know. But at no time does he go further than just kind of tussling with her, which indicates he could very well. I mean, when he met her in the living room, have forced, like you were suggesting, Justice Periente, he could have forced her to the ground, ripped her off her clothes. He does none of that.
Well, I wasn't suggesting that. I was asking you what happened.
Well,
but let me ask a question in terms of the implication of this. Clearly, when we look, and we have a case, I think, this morning, with murders that have a sexual element, where someone is sexually assaulted, raped, and then killed, those cases have a different level in our court because they've got a crime that preceded the death of a sexual battery, at least from my point of view. In this case, there was a general verdict, was there not?
Yes.
Okay. if there is an issue of simply factual insufficiency, and there's a general verdict, and this certainly, in my view, meets premeditated murder for the murder, don't you, even if we found that the attempted sexual battery was slim at best, not typical of cases, it doesn't matter for the guilt phase.
You're saying it's harmless.
Well, I guess I could use that word, harmless,
yes,
because but it's different. It's not harmless in the sense of whether the jury still would have heard everything about what happened. They can draw their own conclusions as to whether there was sexual motives. But as far as whether it was error to submit it to the jury because there wasn't enough for the sexual battery, once it's submitted as a general verdict, it is, if we use the word harmless, it's not reversible error.
Well, I think it is under the United States Supreme Court case Yates versus...
Now, I thought, and I know you're a very experienced death penalty appellate lawyer, that, and you can, and I know you'll either stand corrected or will stand corrected, that if it's legal insufficiency, that is one thing, that is, there wasn't a crime enough, but if it is factual insufficiency, then it is harmless. No? Is that your opinion?
I don't think so. I'll be honest, I'm not quite up to speed on
Okay, well then let's not, because I think that's the distinction. And then for the penalty phase, you would be saying that they would, the attempted sexual battery would be an aggravator that you would say should be stricken.
It should be stricken, right.
Okay. So I just want to, but to me, in the guilt phase, I just don't see that the jury hears, you're not saying any evidence that was admitted shouldn't, like everything that we're saying about the crime, the jury shouldn't have heard it.
Well, they're going to hear it simply because it was part of the...
Exactly. So I maybe he thought he was going to get lucky, then he got upset like some defendants do and said, I'll do it by force. The jury, they could have concluded that, or they could have, whatever happened, he went into a rage and he then murdered her over a period of time that you certainly are not challenging HAC.
No.
So I was just wanting to clarify that for the guilt phase, that from my point of view, it doesn't make a difference. Maybe. Well,
I think it does. Well, like I say, I don't see how you can separate out the attempted sexual battery and say it had beyond a reasonable doubt had no impact on the jury's verdict, even though it was a general verdict. And this court can... But
you're not saying any evidence that should have... That's what I was asking. The jury would have heard.
They would have heard.
If it went back for any phase, the jury would still hear every single fact that we have just talked about.
Right.
And are you challenging the premeditation aspect of this murder?
Not at the guilt phase. At the penalty phase, certainly I argued it wasn't the heightened premeditation for
Right, but I meant at the guilt phase, there is sufficient evidence to demonstrate premeditation, isn't there?
I don't want to concede that, but I can see your point. Let me just put it that way, as far as close to concession I'm going to go to. But again, when you start saying there's evidence of premeditation, and we're going into the jury's mind here, and what the jury may have felt.
Yeah, but when you have a general verdict, as Justice Perriente indicated to you, as long as either one of those are legally possible, then I don't think we have an issue here. Now, whether factually you could have had a murder during the commission of an attempted sexual battery is actually a factual question.
Well, I think it becomes a legal one in the sense that we're saying there's insufficient evidence, so as a matter of law.
How about during the course of an arson?
Well, no, the arson happened after the murder. It was after he's supposed to have killed her. He then went back and somebody got some gasoline and then started the fire. So by that time, the murder was certainly, I don't think it had been during the course of an arson. But the point is, I think, is regarding the attempted sexual battery, what we're seeing is that no time does Cmar go beyond the preparation, the sort of thing we learned in law school. You got to go beyond preparation into perpetration. And if we look at the statute on attempts, the 777.04, there was nothing that really stopped him. Nothing interceded, and no but for something else he would have had.
Which I guess your point being, and he started out with an intent that he would try to have a consensual relationship. He obviously got rebuffed.
Right.
He then had the opportunity to act on a unconsensual sexual act.
That's correct.
In the living room or any other place, and instead of trying to sexually attack her, he killed her.
Right. What happens?
Which is, I don't know if that's better for him, but
well,
it's probably
the way it becomes
certainly not better for her.
Yeah. What happens is she has a knife. He knocks it out of the hand, and in the course of knocking it out of the hand, she apparently cuts it. He's cut his thumb. He apparently at that point goes into a rage and then proceeds to stab her. Now, what really happens that I think is very much closer is we have clearly an aggravated battery that leads into a murder. I think that would probably have been a better charge instead of attempted sexual battery.
Well, that would have been, but our case it merges.
That's right. Not only merges, but but you can't use an aggravated. The aggravated battery is not one of the enumerated felonies. So I think it becomes clear why the state charged her with attempted sexual battery. They wanted to use it as a felony murder, and yet the evidence, I think, at least as I'm arguing, is insufficient to support that.
And your concern, and I think Justice LaBarga actually said it would be interesting if this had stopped at the point when the knife stopped or whatever, whether the state would charge and we would uphold a attempted sexual battery charge with this evidence.
Yes. One of the cases I'd like to talk about briefly is the case actually the state cites in its brief of Godinez. And in that case, Mr. Godinez wanted to have sex with a woman. She retreated to her car, and he's pounding on the windows apparently 3 times, trying to get into the car, and in fact tries to smash the window. All the while he's saying, I want to have sex with you, a little more earthy than that, but says, I want to have sex with you, and then she leans on the horn, and because you know how irritating horns can be, he leaves. This court said that was enough for an attempted sexual battery. Why? Because he would have had sex with her, but for the car window, but for her leaning on the horn. We have nothing in this case similar to that. Nothing really impeded or prevented Mr. Cmar.
What about the knife?
He knocked that out of the hand. He knocked it out of the hand. Nothing stopped him, and nothing stopped him from having sex with her. Yes, sir.
Before we get too far into your time here, I would like to spend some time on CCP.
Okay.
And I think that's one of your major arguments. And I said, am I correct?
Well, I made a cold calculated argument that the murder has to be, you have to meet all 3 elements.
I'm sorry, what'd you say again?
In order to meet the cold calculated CCP aggravator, you've got to meet all 3 elements. It's got to be cold, it's got to be calculated, it's got to be premeditated. And going back to what Justice Quint says, well, okay, we may have had enough premeditation to get past the guilt phase, but we don't have that heightened premeditation here. If we barely have it here, we certainly don't have a cold element, and we don't have the calculated element. We don't have the cold, methodical killing. We don't have the calculation that goes into these things.
So your position is that this was a frenzy type killing?
Yeah, that was part of it. There was certainly a frenzy. That he himself said when he told Falancia that what happened is she presented the knife, I knocked it out of her hand, and in the process I cut my thumb, and then he went into, as Maudlin will say.
When did the frenzy actually begin?
I would say once she presented the knife, he knocks it out of the hand, and in the process cuts his thumb, and the pain from that, and the drugs and all that. I would say at that point is when the frenzy begins. So
prior to that, your position is that he had no intention of taking his knife out and stabbing her?
No. Yes.
So yeah. When she cut him, that's when he lost it and started stabbing?
Yes, that's what we're saying. That's when the frenzy begins, and that's when the intent, if you want to call it that, to kill her begins.
And there's nothing, I guess, in terms of just on this aggravator and comparing it to other cases, if we accept the state's view that his intent was to have sex with her, there is nothing that indicates in what he said to his jailhouse companion or anybody that that's why I was asking about their prior relationship, that there was no motivation that he was going to kill her for, he was upset about...
No. I mean, as Maria Louise was a very quiet woman. She would stay in her room, knit or bead or whatever it was. And as I recall from reading the record, that's about the extent of their relationship. They shared a house together. She was very quiet, stayed to herself. There's no indication, as I recall, of them having any sort of friendly or adverse relationship at all.
I mean, that's
as far as I know, yes.
It's odd that they've been in the house and we don't know if they were friends. Did they eat together? Nothing like that.
Well, you would think so because, I mean, when you got as many people as you do in that house, you would think there'd be something. But as I recall, there was nothing in there indicating any sort of relationship, either for or against, sexual
How many?
relations.
It was a trailer, correct?
I thought it was a trailer too, but I think it's a house. But when I read it, it was a house.
I thought I'd read in the record it was a trailer.
Well, yeah, it may be because I thought it was a trailer too, but then I went back and checked, and there was some testimony saying it was a house.
But you had the defendant, your client, living there. You had his wife.
His wife and two children.
Two children living there.
His uncle Ed. And his father and Maria Louise.
No, his father was in jail at the time.
Well, his father was in the at the time of the murder. His father was in the hospital, as I recall.
I thought it was jail.
Well, he wasn't there. That's how the house becomes.
How many bedrooms are we talking about here?
I don't know. I don't know. It sounds like a crowded house. I mean, she was in the living room at the time when he accosted her. So yeah, it doesn't sound like a very big. I mean.
Did you know whether Louise had her own room? You said she kept it herself.
She was the boyfriend of Cmar's father, so I'm assuming they shared a room. But that, they don't really go into any relationship there. What I would like to, can I stop it real quick? Do I have 9 minutes left altogether, or is that of my 25 minutes? Okay, thank you. I've got caught on that before, but. What I'd like to do is move to the second issue.
Get into your rebuttal and go yellow.
Okay, gotcha. I just want to make sure I've only got about 4 minutes left to impress you here. What I do want to talk to you about, though, is the second issue deals with a conversation that happened after Cmar had been arrested. He talks to this jailhouse informer, snitch, we want to call it, William Valencia, and Maudlin cooks up this idea. He's going to plant evidence. He wants to plant evidence to implicate Ryan Maudlin in this murder. And so Valencia says, I know somebody can do it. As it turns out, that somebody was an undercover cop. The undercover agent then, through a course of 4 conversations, agrees to for $300 to plant some clothes that would somehow implicate Maudlin in this murder. Cmar then talks to his wife and says, honey, I need for you to get $300 and we'll get some clothes and we're going to, this is what's going to happen. At trial, that essentially comes out. The state calls Miss Cmar twice, and on at one time, she goes into this conversation she has with her husband. The defense objects to it, saying that's a spousal privilege, and the state says, no, that's not spousal privilege at all. That's they're conspiring to commit another criminal act or do something criminal, and the court says that's right, go ahead. Under the spousal privilege rule as codified by 90.504, there is no exception to the spousal immunity or spousal privilege.
Was the content of that conversation testified to by anyone else?
The undercover agent will say that, and I believe Valencia will say that as well.
So whether she actually testified to that or not, the substance of what went on would have come into evidence anyway.
Well, it would have, I suppose, but the real question is, how much credibility do we give William Valencia? Because he's the one who provides the details.
Didn't she also tell the undercover agent that also?
I believe so.
So
well, okay, we're asking harmlessness here. That is the real issue here, because it's clearly not. So the question, Justice Quince, is it harmless? The question really becomes can we believe William Valencia? Because he's the one that provides a lot of the damning details of the murder, because he claims that while they're in jail, Cmar will tell him some of the details. And so when you have the wife coming in, essentially bolstering what Mr. Valencia says, then you have his credibility is enhanced. And the question then becomes, is it enhanced, and can this court then say that a violation of the law is harmless beyond a reasonable doubt? And I don't think you can, because of Valencia's enhanced credibility. Now,
But you said it was harmless, but it's not harmless. It's a waiver.
well, what I'm saying is, yes. Well, first of all, I'm saying the court erred in allowing that testimony in as a waiver to the.
Why is it not a waiver?
Because
he had the same conversation with the undercover agent that he had with his wife. Once you let the cat out of the bag, it's a waiver.
Well, that certainly wasn't argued below. And what we find is the court went strictly on that it was an exception to the husband-wife privilege, which is not covered in the rules. Now, let me. I see I've just about run out of my time here, but I appreciate the time you have. The other 6 issues are good issues, but I don't simply have enough time to argue them. But I would appreciate, I know you're going to give them full consideration. And if you do, I feel confident to reverse his judgment and sentence reverse for a new trial, or at least a new sentencing hearing without the CCP aggravator. Thank you very much.
May it please the Court. Assistant Attorney General Charmaine Millsaps representing the state.
Could you speak up, please? Try to speak into the mic.
Sure will. All right, I'm going to talk about the same 3 issues that the Court talked about.
I'd also like you to address this issue of the statement and the rule of completeness. So just you can do that after.
I'll be happy to get to that as well. All right, starting with issue 1, attempted sexual battery. Your Honor, this Court has rejected a very similar argument in Godinez. You found it to be, and I quote, wholly without merit and straining credibility. Your Honor, if you want to get lucky with a woman, that involves tulips and chocolates. It doesn't involve shoving matches. And this was not one shoving match. There were 2 of them where after the first shoving match, she then feels threatened enough. She goes and locks herself in the bathroom. But this is the house.
Could you fill in anything about, from the record, the relationship between the 2 of them, the age of the victim? Certainly we must have that in the record.
Your Honor, actually, the age of the victim, I have the defendant's age. He was 24 years old at the time of this crime, nearly 25. This was just a few days before his birthday. Let me explain who moves into this house.
So we don't have the victim's age?
I don't have the victim's age. I think she was in her 30s.
I mean, again, in terms of whether there was a relationship.
So let me tell you about that. Okay. Who moves in where? Okay, he moves in on, this crime happens in December. Cmar and his wife and 2 children move in October. She moves in November, and this crime happens December 13th. Okay, so they have not been living together in this house for long. That's basically a little over a month. He moves in October, she moves in November. This crime happens in December. Okay, and it's not clear whether it's a house or a trailer. I couldn't see that. I think it's a house. The front bedroom, the front den, they describe it as a den. She is using that as her bedroom. The defendant's father is in jail. The defendant's uncle is in the hospital, okay? So we've got an uncle who lives there. This is actually the grandmother's house. And they do refer to it as house when they say who it belongs to. So, but I don't know, people can mean that in the colloquial sense. Okay, it's the grandmother's house. Uncle Ed lives there. Uncle Ed lives there but is in the hospital. The father lives there with his girlfriend who is the victim. The father's not there. He's in jail. The defendant lives there. He moved in just in October with his wife and 2 children. Okay?
So the idea, let me just, about the comment of, I hope I get lucky. It's got a 24-year-old saying that, which sort of puts it back to, what age somebody is. And he's a big man. Is he a big man?
He's 6'5" and weighs 280 pounds. He's got 150 pounds and a foot of height on her. We do have her weight and height.
I would imagine that if somebody of that size in a trailer where no one else is wants to get lucky and lucky to have sex and not be consensual, that what would have stopped him after she obviously refuses from raping her?
She runs in the bathroom and locks herself in.
So what you're saying is that there was no opportunity for him to act on his sexual intention.
She basically keeps taking herself out of the equation. Okay, first they get in a shoving match. There are 2 shoving matches here. They get in a shoving match. She manages to push him far enough away to run in the bathroom. It's somebody else's house. He probably does not want to kick in the door. Not that he's not capable of it, but that doesn't reflect his intention. He then goes outside and pounds loudly enough that we have a neighbor and the neighbor's grandson testifying that they hear this.
We know all those facts. The question is, in my mind, it's very, maybe we've upheld an attempted sexual battery where there's no clothing that has been torn or something that begins grabbing. We have in what case?
In Godinez. That's why I cited it.
And what had been said in Godinez? In other words, what was the statement that we based the upholding of the attempted sexual battery?
He screams like the defendant here. In Godinez, he says he wants to F, and you have slashes after that. That's what Godinez said, according to your published
So we would
opinion.
have to say that when someone says, I hope to get lucky, that's their intention is to rape somebody?
Getting lucky, you can say you want to get lucky all you want. That's not the state's theory on why this is attempted sexual battery. This is physical. He comes in the den. They have the den. They have a mattress. That's where her bed is. Okay. So yes, the house is very crowded. Okay. He makes advances to her. Remember, those advances could be, advances is all it is. They could be physical touching. She pushes him away. She runs away, locks herself in the bathroom.
When you say about the advances, it could be that he touched her on the breast, but that would be speculation. We don't know.
We know whatever he did provoked her to shove him and run into the bathroom.
From the state's point of view, there's no question that this is an HAC. There's no question he did this murder. At least that's not being raised as a defense. There's no question that the way he killed her was HAC. So we've got a first-degree murder case, and we've got a case that has unquestionable HAC. Now, I don't think it's being contested.
Nor is the prior violent felony.
Or the prior violent felony. The issue really is not necessarily for this case, but for all cases. We've got to just make sure that we don't expand the law to put somebody in prison that isn't, where the circumstances don't justify it for the crime they're being charged with. If you don't have attempted sexual battery, is there another felony for felony murder that the state had?
No, Your Honor, we went on attempted sexual battery.
Okay,
but you also more happens here. But
you have also went on premeditated first-degree murder.
Yes, Your Honor. It is in fact all harmless.
It was a general verdict.
It was a general verdict.
So can you and I know we may disagree, or I might agree with you. I don't know honestly on the facts. I think I want to look at it, but it's harmless, correct?
Absolutely, Your Honor. It is absolutely harmless. This is a Griffin, not a Yates claim. And then I'm going to tell you that Yates has been overruled anyway by the United States Supreme Court. They're both subject to harmless error. But sticking with what this is, the law has always been, according to this court, when it's claim of legal insufficiency, then factual insufficiency, then Griffin applies, and you do harmless error analysis. So let me do a harmless error analysis. The victim here was stabbed 93 times. Some of those stabs, when she was trying to run away, were in her back. 5 of those stab wounds were in her back. It is the last slashes to her throat that kill her. Most of those 93 stab wounds occur first, and the reason Dr. Giles, the medical examiner, said that was if you slash the throat at the beginning, well, first of all, she died very quickly because those were very fatal wounds. But you would also breathe in blood. There was no breathing in blood. He testified that the fatal wounds to her neck occurred at the end of the 93. So this is clearly premeditation. This is clearly a premeditated murder. And so therefore, since this is a claim of factual insufficiency, it's Griffin, not Yates, that applies. But the United States Supreme Court has receded from even Yates. They're both subject to harmless error, factual or legal insufficiency. It's subject to harmless error. This is clearly harmless in this case.
And when you do harmless, it's not, I mean, first of all, as I asked Mr. Davis, there are no facts that would not have come in no matter whether the state had charged attempted or sexual battery or that went to the jury. So there's nothing factually that doesn't come in no matter how this case is charged.
Yes, and Your Honor, quite frankly, probably even a lot of this, we would argue this is motive. You're going to explain, you're going to have to explain why are they shoving each other? Why is she locking herself in a bathroom? Why is she going to the kitchen and getting a knife?
And I don't think Mr. Davis, he agrees too. So the harmless error is that if there's enough for premeditated, that's all you do.
That's all you do. Okay. You look at, and that's a proper way to do harmless. What I'm arguing here, you would look at the evidence that goes toward his intent.
But isn't that a different harmless? That's why I wasn't sure I liked the harmless error. Harmless error, as far as evidence that comes in, is whether it's harmless error beyond a reasonable doubt. I didn't think Griffin was that type of harmless error. It was really just that there's enough to go to the jury on the factual, on the alternative theory. And we assume there was enough, they found both, something like that. Isn't that, so it's a different type of harmless test than Tuguelia.
No? It's a different look. I'm not sure it's different in terms of, what you do is there sufficient evidence on the alternative theory?
Well, that's not a harmless error for Tuguelia. That's a different type. That's saying the jury would have
convicted of first-degree murder anyway, yes, because there is so much evidence of premeditation. That's how that kind of harmless works. So what I'm really saying is there was a massive amount of premeditation, that being the 93 stab wounds, including 5 in the back where she's trying to run. Okay, and that it's the last ones. The medical examiner also describes her defensive wounds, one of which cut the web down on her left hand down to the carpal tunnel bones. So he says this attack this was not short. He said it took it. I don't think he said significant. I have the exact quote in my brief, but this was not short. So that is very much premeditation. The types of wounds, the number, the final ones being the fatal ones. Then I'd also like to talk not just about issue 1, but I'd also like to talk about issue 2. That is the husband-wife privilege. First of all, Your Honor, my brief may be a little confusing. There's no joint crime exception in Florida. All right, I was just explaining that is, Earhart, for example, advocates it, but it's not in our statute.
It's been used in federal courts.
It's been used in federal courts, yes it has, but only one DCA's reached it, and they said, and it's not in the text of the statute. And what's more is I've learned that there were proposals in front of the legislature, and they were not adopted. So I think it's quite fair to say the law in Florida is that there is no, why it may be a good policy, the law in Florida is that there is no joint crime exception. All right, so, but I'd like to talk about the husband-wife privilege. First of all, no matter what view you take, facts and acts are outside the privilege. The fact that she went to, the wife went to McDonald's and paid the undercover, his name is Detective Humphreys. She thought he was Carlos. He was an undercover. She paid him. She met him at McDonald's, and she paid him $200. And then she met him again in the parking lot and paid him $100. Everything about what she did and who she met and what she gave to whom and whom she paid, those are facts and acts. That's not covered by privilege. So the overwhelming majority of this is, in fact, never been covered under any view of husband-wife privilege. And what's more is opposing counsel really relies on the fact that the cellmate, Bill Williams, is a 3-time convicted felon, and so it's not believable. But notice how what I say has absolutely nothing to do with the cellmate. Not only did the undercover cop testify himself, but we recorded the defendant talking to the undercover cop. My wife will get together $300 and pay you for planting this evidence.
Actually, as you say that, so the argument is it harmless or waived?
Well, Your Honor, I looked at it more as harmless, but to tell you the truth, I think it's waived because
how can it be a waiver? Because no one's agreed to waive the words spoken between the man and the woman. So those extraneous facts don't go to waiving the privilege. Those are extraneous facts that come into evidence anyway.
Well,
a waiver has to be a voluntary relinquishment of the known right there.
Well, I agree with that. Then, in that view, it would be more under harmless. Understand every...
She did not make the statement to someone else, and then that other person come in, right?
Well, no, the defendant made the statement to somebody else.
Well, then that comes in evidence, but not her statements, though.
We have a recording from the defendant.
But not her statements. The question on the privilege is whether the wife has to testify. Isn't that what it's about?
The question on the privilege is whether the defendant's words come in, and what I'm telling you is...
To the wife.
And the exact substance of that was on a recording that the jury heard.
But what you're doing is you're now going to, if it's error, it's harmless, is what I'm understanding. Yeah.
That's how I looked at it, Your Honor, in my brief. I looked at it more as harmless than waiver.
Well, we got to make sure about this because we got important evidentiary issues. Now, on the issue of this tape recording, and I admittedly have not gone back and looked at cases, but I understand that here, in terms of the context of what he was saying to this officer, who he thought was not the officer, was he was going to have him cover up. He goes, well, I didn't do this, but, because I'm innocent, but I'm going to frame my friend anyway.
We're moving to rule of completeness.
We are. Okay. And what the issue being that if he is not offering this testifying at trial, where you would have, of course he'd get impeached with prior violent felonies, but in terms of giving the whole context of what he was saying, again, to me, it's like no one's going to believe that he did it even though he's innocent, so it's it may end up being back in the harmless category, but I don't understand how someone gives up and has to have the other crimes come in when the whole statement is, other than that, is coming in, and so it's taking it out of context. So tell me where the rule came in that says that if somebody in the course of an undercover discussion, or say he says this to his jailhouse mate, cover up, but I'm innocent, that you only get the part that's bad for him, but you don't get the part where he explains that he's innocent.
Remember, we were quite willing to, as opposing counsel says, play everything. Remember, we said we'd be happy to play this.
But you said it would have to...
But then, under the statute, and let me read you the statute number. You're saying, where are we getting this? 90.8061 is where I'm getting this. There's a statute that says when a hearsay statement has been admitted into evidence, okay, it may be attacked as normal, and that means by impeachments. Your Honor, that's in our evidence code. I'm getting this. Not only is there a first DCA case, okay, not only do the treatises such as Weisenstein say that's how this works, but there's a statute.
But this court hasn't interpreted that statute.
Your Honor, there's no No, you have not. You have not directly reached this. You've reached it as cross-examination, not as you've reached it.
Which is a very, to me, and I will look at it, I just did not understand that in order where the state is trying to show something that is harmful for the defendant, but the context of the whole statement, like if he, where at some point he's going, this, but I'm innocent, that it's taken out of context, and the only way that the whole context comes in is if you impeach him by showing his prior crimes.
Because that's what the statute provides. Your Honor, he does not get to put a statement and then in a hearsay statement denying it, and then that would leave the jury without any means to assess the credibility of that. That would be testifying without cross, testifying without impeachment. That's just...
well, I know you've said that where...
8061.
I mean, I can understand it where someone's trying to get... where the defendant is trying to get in a statement, say in a police interrogation that was... and of course, many times it does come in, actually. I mean, all the times that there are confessions where they keep on first saying they're innocent, I've never seen a situation where when that comes in, or the state, wants to, you see all of what's happened. Now, that's different?
Very different. The state cannot do this, Your Honor. Don't misunderstand my position. It's when the defendant wants it in. The state couldn't use the rule of completeness as a means of getting in his priors. It's when he wants it in.
But
okay?
Can the state go in a case where there's a confession and tell the judge, all we're going to do is we want to just bring in the ultimate confession. We're not going to do the all of the other situations where they were protesting their innocence?
And then if the defendant wants the whole thing played,
that happens. See,
then that's when it would happen. When the defendant brings it in, when the defendant invokes the rule of completeness, then this is the price, and it's just brutally clear under this statute. That's a correct interpretation, and not only as the first DCA, you have not done it in rule of completeness, but the first DCA has, and the treatises are all there. No matter how the defendant gets his statement in, for the jury to be able, now he's the one who has to do it. State can't use this as some cute little mechanism to get his priors in when he doesn't testify.
So even
he has to invoke the rule of completeness.
What if the statement itself, if it were to come in the way the state wants, it would be misleading? Even then, it's like the judge has no discretion to say, no, you can't get in that part because it's going to take it out of context. It has to be. See, and again, I just want to make it's just. I appreciate, and you may be 100% right. I'm trying to understand this in terms of how the state could skate around something that might be marginally helpful. Again, I honestly don't see how this would, in this case, would make any difference.
Totally harmless in this case.
Yes.
But like you say, we're concerned this is the Florida Supreme Court. You write opinions in death penalty cases. That law governs not only all capital cases, but non-capital criminal cases. I understand that. Your Honor, I think you could probably give me a hypo where I would say that the rule of completeness could, under the judge's discretion, be invoked without the defendant's priors.
Well,
and it's not just his prior violent felonies, it's all 4 convictions here.
What if the state has a tape like this? In it, the defendant makes many statements and the whole thing is played without any discussion about redacting anything. The state just plays the whole tape, and in there he says he's innocent. Does the state then also get an opportunity to come in and say, okay, this guy has all these priors and all this?
No, and
without the
saying,
defendant taking the stand.
That's what I'm saying about the state can't use this as some cute little way to get his priors in. That's your hypo. The state plays it, and then impeaches him. It's because he wants it in. It's because he's invoking the rule of completeness. Your Honor,
and you're saying if the judge makes the decision that to be complete, that is to not mislead the jury, it needs to come in if the state wants it, then also the defendant doesn't get the have to have the prior felonies coming in.
Yes, and let me give some context to that where I think it would work and where it would not. When the defendant wants his exculpatory statements in like this defendant did, then yes, we get to do this. But let's say a defendant said something that put it more in context but wasn't exculpatory. Do judges have discretion under the Florida's evidence code to say, yes, in this unique situation, because I think pulling it out, I think the rule will always apply. The rule I'm advocating that is, it's just the statute, would always apply if the defendant wanted his exculpatory statements in. But other statements that put it in context, I can't think of an example for Your Honor. But in those, no, the trial judge would still have discretion. This isn't an automatic, I don't think this is automatic. I think he's still, I think you could probably say the rule of completeness requires it without 90-806-1 being invoked. Well, but when he wants it to put in an exculpatory statement, absolutely, this was the correct rule.
What if the rule was, you know, whenever the state wants all the prior bad acts of a defendant, they always use inextricably intertwined if they're unrelated. Why wouldn't the same kind of concept that if the statements within that are the state's trying to keep out to sanitize the context because it's what to show the bad part but not show the context, that if the statements made were inextricably intertwined with what was said, that it needs to come in. I mean, we got to give some guidance to trial courts on this. Would that be an appropriate test?
No, I'm sorry.
No?
You lost me.
What is being said, the statement that whether it's a confession, whether it's whatever, if the part that the state is trying to keep out so that they can make the admission as bad as possible is the part that the state is attempting to exclude is just intertwined with what is being said, then it ought to come in. It's not that the defendant has to be the one to say to be complete. The rest has to come in. The state and the trial judge have an obligation to make sure that misleading evidence doesn't come in before the jury.
Inexplicable, Your Honor, it's hard to do it in the abstract. Inexplicably intertwined, what you're really saying is you couldn't pull out the statements?
Maybe that would be, and I'd have to look at this again, how it was said.
Okay, but now the rule, it's called the attacking and supporting the credibility of a declarant statute, 98061. This is the default. I'm not saying it's always invoked, and it's always, the minute you do rule of completeness, you always do that, but that's the default. If the defendant wants his exculpatory statements in, the defendant, then this rule applies, and yes, and that's the problem here, his 4 priors would have come in, not just his prior robbery that we used as the prior violent felony. He had more convictions that were not violent, and so all 4 of them would have come in.
Could you address the CCP, and also in the judge's sentencing order, apparently he didn't put the right stipulated aggravating in. In the order it says the capital felony was committed by a person previously convicted of a felony and under the sentence of imprisonment or placement of community control or felony probation. But actually what the stipulation was the second one, the defendant was previously convicted of another capital felony or of a felony involving the use of the threat of violence to the person. How do you, apparently the judge put the wrong.
Okay, the stipulation was to a prior robbery where the co-perpetrator had...
yeah, I understand that, but I'm saying, but what he announced on the record and what he put in his and the sentencing order was different than the stipulation.
Well, but, Your Honor, I'm not sure. I mean, the defendant, there's no doubt, and has been stipulated to, that he had a prior violent felony.
I understand
the aggravator.
that, but I'm saying what effect, if any, does the fact that he put the wrong stipulation, put the wrong
Absolutely
aggravating?
none, because there's no dispute that prior exists. Now, if you're saying you want to clean it up on appeal for...
That's what I'm saying.
Because these cases, quite frankly, Your Honor, these cases last 10 and 20 years. We don't want something wrong if we can correct it. I would urge you to correct it in your written opinion. Yes, but
can we correct it, or do we have to send it back to let the judge correct it?
No, I don't think you need to do that. I think you can just say, here was the stipulation. Remember what a stipulation is.
I understand.
Yeah, a
but
stipulation
that's not what he
is
said,
we
and
agree.
Yeah. I'm just thinking about, they want to find something to hang the hat on, and if he agreed to 2 and not to 1, and you put 1 in, is that subject to attack?
Well, he agreed that his robbery.
Yeah.
Yeah, he agreed to his robbery, Your Honor.
But he wasn't on probation or community control.
No, Your Honor, not that. Well, actually, he may have been for one of the other crimes. The defendant actually has the only one that was violent, and therefore the only one that we used as a prior violent felony was the robbery that I was telling you about. But there were other crimes, burglary. He was on sex offender probation.
I understand that, but could you deal with CCP a minute? Just one minute.
Okay. Let me deal with CCP. First of all, Your Honor, under this court's case in McWaters, hopping straight to harmless, in McWaters, you struck the CCP in McWaters, and then you had 3 aggravators remaining. They were the exact same 3 that are here: the prior violent felony, during the course of a sex back, and HAC. There was
so you're basically saying it's harmless if there isn't CCP?
Under this court's there's a case directly on point, Your Honor.
I just want to hear you say it.
How do we know it's harmless for the jury if the CCP shouldn't have been submitted to the jury?
Well, but, Your Honor, you always do harmless like that. I mean, this court always does harmless like that. They never say... That kind of logic is we could never do harmless because we wouldn't know whether it was harmless to a jury, but we don't do that. We look at the actual facts and decide it's harmless, and we do it up on appeal. So whether or not it was submitted to a jury or not does not, it's still harmless. And there's literally a case directly on point. McWaters is directly on point. You struck the CCP, same 3 remaining aggravators. There were 4 aggravators here. Even if you strike the CCP, they're the 3 remaining. There was no statutory mitigation here, just like there was none. You referred to it as minimal mitigation in the McWaters case. And then there were 14 non-statutory things like kind to animals, loyal friend, good, reliable business partner, all accorded slight weight. So this is directly, McWaters is directly...
Where would we be if, in addition to CCP, that it would be determined that there was no attempted sexual battery under these facts? Where would that then leave us under your analysis?
Well, I still think it's harmless. You still have 2, no mental, and 2, you have a prior violent felony, and you have HAC, and the HAC here is not only not attacked, it's literally rock solid. And you have no statutory mental mitigation, and you have only 14, but now some of them, Your Honor, have a little more substance to them, like raised by an alcoholic father. But all of them were accorded slight weight, so I still think it's harmless. And, Your Honor, to do that, you're going to have to receive from Godinez. This case has more overt acts than Godinez did. And so I...
Well, it seems to me that Godinez has to turn on the verbal aspect. Because if every time someone beats on a car, that turns into an attempted sexual battery, or every time there is some physical touching by a male of a female, then attempted sexual battery has no meaning at all.
Well,
and that's
okay,
just
but
seems
now remember,
problematic.
we have the screaming here too. Both neighbors testified that when he went outside, that they heard pounding. And
I hear pounding. What was said outside, though? I didn't hear anybody make reference to a sexual attack outside.
she said she heard the F word. I think that it was the grandmother.
Okay, what is it? Just quickly, because you're past your time. What was said outside while the beating on the window was going on?
She
the
just
record
said
shows.
screaming obscenities. Okay.
Okay.
But not saying, I'm going to F you.
Well, no, just obscenities. Remember, she said obscenities, and she said cussing. I mean, she did use that word. But, Your Honor, we have a lot more. We have 2 shoving matches, locking in the bathroom. That's a lot more than happened in Godinez. And we have screaming.
I mean, but again, with the absence of some sexual overtone, that would convert every physical, aggressive situation into an attempted sexual battery.
Multiple shoving matches instead of tulips?
That's what I'm saying.
Yeah.
That's what you. Well, I mean, you say that's not a threat. I mean, to get lucky, that's not really a threat. That's.
No, Your Honor, we don't mind a bit about the get lucky. Mine does
well,
not.
Then you change when it doesn't fit your needs.
No, it's
Okay,
the means
right.
in which he was getting lucky. I'm saying you can want to get lucky all you want, and as long as it's tulips and chocolates and dinner, that's fine. But shoving matches, locking in bathrooms to the point where this victim
But coupled with the prior statement is what it needs to be. You don't agree with that?
Well, but yes, Your Honor, we have
Needs to
both
be
of
coupled
this.
with something with reference to the sexual aspect of it.
Well, now, wait a minute. If a defendant literally attacks somebody and didn't say a word,
Right.
and she manages to get away,
Right.
He never says a word, but he rips her clothes.
No, there's no ripping of clothes off. I thought you said there's no ripping of clothes
There
here.
isn't, but you're asking me a hypo about there must be words, and no, there does not have to be
All right,
words.
that's fine.
Okay. Thank you, and ask you to affirm the judgment and sentence and death sentence.
As to the rule of completeness, in this case, as I recall reading from the record, we didn't even get to the impeaching with the prior record. The defendant said, look, if you're going to put in some of it, you got to put in all of it. And that was essentially his argument. And that was, the court says, and that's as far as they got. We never got to impeachment with prior records or prior convictions or stuff like that. So that discussion, in a sense, is irrelevant. The real question is, under the rule of completeness, should the court have let this evidence come in? And then, yes, I mean, his exculpatory statement, yes, I think under the rule of completeness, it should have come in. And I think, Justice Perianto, you've probably summarized my argument better than I could.
But I don't know if I'm right.
Well, yes, you're right.
Well, I know you can say I'm right, but Ms. Millsaps is saying that the evidence code is very clear on this subject.
Well, as to maybe perhaps the impeachment with the prior convictions, but we don't get to that point. The issue is under 90.108. Is, in fairness, should the entire statement come in?
But let's say it should have come in. But I thought what it was is they said it could come in, but your prior convictions are going to come in.
No, I don't think they got that far. It was just simply, I'm.
But let's assume that the defendant wanted it in, and everyone agreed, but it was going to be at the cost of the impeachment with the prior convictions. Do you agree that the statute mandates that is how this happens?
That they were then begin to impeach.
If the defendant is the one, not the state putting it in, not the judge saying it's not, you can't separate it to the state, so you're going to either have to have it all in or not, but where the defendant says they're leaving out parts that I think should come in, and the judge and the defendant says fine, and the state say fine, but your prior convictions are going to come in. Do you agree that that's what the statute says?
Well, first of all, which statute? I guess we're talking about
the statute that Ms. Millsaps referred to about.
No, I don't think so. I mean, because why just simply stop with convictions? Well, if there's anything else that can impeach.
But I'm not. But I thought. Okay, I'll look at the statute and we'll figure it out. What about the harmless error on if we strike CCP and attempted sexual battery?
Then you're down to a 2 aggravator case.
Well, we know it would still be. There's no question that this would still be proportionate. that's not harmless. You would, I mean, I would say, I will just tell you that even without attempted sexual battery, that this has heightened HAC and it has prior violent felony. So it's still proportionate. The question is it harmless in terms of whether the judge or the jury would still have recommended an imposed death?
Are you saying that under the harmless test in Giglio, it had the absence of those two, the presence of those two aggravators would have had no impact on the jury's recommendation of death?
I'm not saying, I'm asking you how we've analyzed it in the past.
Well, that's, if you're going to find, if you knock out...
She said McWaters is controlling.
Well, what you're saying is you knock out not only CCP, but the attempted sexual...
That's what the question was to Ms. Millsap.
Right,
I'm asking you.
And I'm saying, no, it could not be harmless, because you would not have instructed the jury that they could have found those aggravators, and then you're down to basically a two-aggravated case with some mitigation. And
do you agree it's very weak mitigation as we look at these cases?
It doesn't have the statutory middle mitigators, but at least the court didn't find them. But certainly, the jury could have found that he committed this in a frenzy.
Did you have mental health mitigation?
No, there was no mental health mitigation. But you don't necessarily need the expert. That could have been argued to the jury. So what I'm saying here is that no, it would not have been harmless to eliminate those two aggravators. With that, I think you understand where we're getting at on this argument. Appreciate it. Thank you very much.
We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All rise.
Court will now take up the second case on our docket, Simmons versus the State of Florida.
Good morning, and may it please the Court. My name is David Hendry, and I, along with Jim Driscoll, we come from CCRC Middle region in Tampa, and we represent the appellant petitioner, Eric Lee Simmons, in this case. Eric Lee Simmons is a quiet, compassionate, innocent young man who was subjected to the most coercive of interrogations that this court has ever seen in the history of jurisprudence.
Have you had an opportunity to see the tape of the 2 hours version of the interrogation? Have you seen the actual interrogation?
Absolutely, Your Honor.
Because, I mean, it's like anything else. I mean, if you read the allegations that you have made and you see the tape, I mean, it looks a lot worse on paper than it does on tape. I mean, I see what you're saying, that you're claiming that in this instance, the police officers did all kinds of things, such as threats of the death penalty, insinuations that they could convince the prosecutors to be lenient, suggestions that the defendant, the client, would not receive a fair trial, attempts to shock him by pounding on the table and lunging forward at him, threatening with the electric chair, that type of thing, threatening to search his father's house and screaming at him. But and calling him hoss, I don't know exactly how that's threatening, but I know if you read that on paper, it seems very ominous, but when you see it on tape, it's not as bad as you describe it.
Well, I would disagree with that, Your Honor, and I would point your attention to, and this Court's attention to, page 2 of my initial brief, where I watched the tape, obviously, very carefully, many times, and as I said here, the appellant strongly urges the Court to view the DVD as it analyzes this case. The most coercive and threatening 8 minutes of the interrogation are located at camera counter 2358-01 to 000335, and then again at 001358 to 001701. So we're dealing with a 2-hour videotape, Your Honor, and I have highlighted here for the Court the most coercive 8 minutes of this interrogation. And if you watch it, there are lunges towards the defendant. It is actually Detective Perdue says, "I'm going to send you up the river, give you a lethal injection." And Mr. Simmons, he denies this over and over and over again, perhaps 200 times. And at one time, very late into the interrogation, he says, again, "I didn't kill the lady. I ain't killed the lady." And what was the response? You can go ahead and say that when you're lying there on the table with the IV sticking in your mouth.
What is it that he said that you're trying to suppress? What was the statement that he said? I think it was one line.
There were actually two very important portions of the tape. The final statement at the end of 4 hours was, "If you found blood in my car, I must have did it."
Okay, that's the one line. The other portion is the fact that he mentioned that he had consensual sexual relations with the victim 2 weeks earlier. Is that what you say? And that's the other part? That's bad?
That's Your Honor, what we have here are 2 hours of recorded interrogation. The other two are not. And what happens is the transcript we have available, not only a videotape, but almost a full transcript. There's some inaudibles. But in the first 2 hours of the interrogation, which is transcribed and on tape, he says it was Saturday and I was drunk. It doesn't appear that he said I had sex with her 2 weeks ago. And Detective Perdue said that it was off tape. It was part of those 2 hours that were not.
Right, but that prompted defense counsel to enter into a stipulation with the prosecutor, which was read to the jury twice. And in a stipulation, he agreed that the semen found in the victim's vagina, washings, belonged to your client. But the allegation of sexual battery in this case was not vaginal penetration, it was anal penetration. Yes, and I saw the picture, which is very graphic. So didn't that stipulation help you? I mean, it seemed like if she was raped anally, and that's the whole theory of the state's case, and he is claiming, no, I had sex with her 2 weeks ago, but I had sex with her, but it was vaginal. Doesn't that stipulation actually help you?
The stipulation as presented to this jury absolutely condemns Mr. Simmons to death row in this case. That stipulation should have read that the semen evidence was evidence of consensual sexual encounter. Just because the stipulation said that this had nothing to do with the sexual battery charge, which was anal penetration,
well, the stipulation says it is not relevant to the sexual battery charge herein, as that charge involves allegations of anal penetration.
Yes, sir.
And it is not to be considered by you in any way as to that charge. Well, how does that hurt you?
So it is relevant to prove kidnapping and murder, which it is relevant for the state. It goes to tie this defendant. The jury's reasonable inference from that evidence is that Mr. Simmons' semen is inside of this woman's vagina. It is inside her vagina because he's the man who kidnapped her and killed her.
Is that the way the state argued that?
Yes, Your Honor. Yes, Your Honor. Ms. Orr, the trial counsel in this case, she candidly admitted that she made a mistake, and it was a major error on her part for failure to put that consensual nature in the stipulation, because when the stipulation came about, Ms. Orr was objecting at trial, and she was saying, Your Honor, Mr. Sean Johnson is testifying here, and he's making reference to a sexual assault kit. Ms. Orr said, when he's making reference to a sexual assault kit, it makes it look like this was a rape, and this was not a rape. So Ms. Orr, she knew she had the depositions of Deborah and Edward Johnson to show that there was consensual sex on Saturday, December 1st, the night that someone else kidnapped and murdered this woman. Eric Simmons had the misfortune of having consensual sex with this woman before she was kidnapped and murdered. The jury did not hear that this was consensual sex. They were only left with an inference that this woman, left very badly sexually assaulted, was sexually assaulted by Eric Simmons. And with regards to the interrogation, not only do you have Detective Perdue banging on his knees and said, I'm going to send you up the road for a lethal injection, Detective Adams pounded on the table and said, I'm tired of messing with you. He goes, he's tired of the denials. Eric Simmons had to say, you got to get out of my face. Most importantly here, Your Honors, at 3347 in the transcript, Adams said, Simmons stated he'd had enough, and we ceased the interview. That's it. Mr. Simmons had enough. How many times does he have to deny this offense before the police keep coming at him and coming at him, threatening him with an electric chair, lethal injection, and an IV sticking in his arm?
Ms. Orr, defense trial counsel, testified during the evidentiary hearing that she filed a motion to suppress the detention of your client being taken into custody, but she did not include the argument that about the coercion during the interrogation. What explanation did she give for not pursuing that argument?
She felt, Your Honor, that the Fourth Amendment grounds of an illegal search and seizure were going to be granted. So she said, again, she candidly admitted that she stopped short of what needed to be done. Although she filed a motion to suppress based on Fourth Amendment grounds, illegal search and seizure, she did not take that extra step and raise the issues of Fifth Amendment and 14th Amendment concerns of this was a coercive interrogation.
She also thought she was going to win in phase one and didn't really pursue a penalty phase, and we'll get to that in a second. But that wasn't argued at all, the coercion part of it.
Oh, no. Was not brought up. This court did not discuss that there were specific threats of electric chair, lethal injection, and an IV sticking in his arm, to the point where Simmons told him, and it's recorded, and he says, look, I have very small veins and it's hard to stick them. And so I want to point the court's attention because there's a glaring error in the lower court's order where the lower court states that Professor Richard Leo's testimony would not be admissible. And at the time that this case was pending the decision, this court issued the case of Blaine Ross, where it talked about the use of false confessions experts. And this is based on, it goes way back in 1980 to the Brewer case from the Florida Supreme Court, a coercive interrogation that involves these types of threats A statement as the result of such coercion is totally inadmissible. I've also cited to Rogers versus Richmond, which was a 1961 U.S. Supreme Court case, over 50 years of jurisprudence. And I also cite to, because this trial judge said that this testimony is not admissible, there's a case right out of the second DCA, and that's the State versus Sawyer, a 1990 case where it says the tapes, because we had, in that case, the tapes reveal that Sawyer was harangued, yelled at, cajoled, urged approximately 55 times to confess to an accidental killing, promised assistance with the state attorney's office if he did, if he told the truth, threatened first-degree murder and its attendant consequences if he did not cooperate, warned what happened to a fellow policeman in Clearwater who played games during this interrogation and got charged with first-degree murder, threatened that he would return to alcohol from remorse if he did not admit the killing, and even threatened with eventual death from alcohol consumption. The state, this is what State versus Sawyer, a second DCA case, right in the same jurisdiction as Lake County.
Let me ask you. I understand where you're going with this, but I want to concentrate a bit on trial counsel. My understanding from reading the record is that trial counsel, and I'm a little confused here. You got Ms. Orr, and what is the name of the second chair?
Jeffrey Pfister.
Now, Ms. Orr was not qualified.
Yes.
Under our rules to try this case. So I take it Mr. Pfister is the one that was qualified?
That's correct, Your Honor. There was a battle for Mr. Simmons. He wanted a change of counsel. He wanted Ms. Orr to represent him because she had a very good reputation in the jail there, and he was very unhappy with the services of the public defender. So Ms. Orr wanted to try this case, but she couldn't try the case, I believe, because she might have been one case short of what was necessary for capital trials. So she was not death qualified. She was very close. So what she did is Mr. Jeffrey Pfister became actually the first chair, and then she would be the second chair. But she virtually conducted the entire trial. Jeffrey Pfister said, I was just sitting there. I didn't get paid for the case. He was basically just sitting there as a figurehead, and he did not participate at all in the penalty phase.
Going to that, because again, time is limited, and there are just a ton of issues in this case. She, I believe, her testimony during the evidentiary hearing was that she basically threw all her eggs in the guilt phase basket.
That's correct.
Didn't concentrate much on penalty, and she was shocked that the jury came back with a guilty verdict, in this case, given the evidence.
And our position is that she only utilized half the eggs that were available to put in that guilt phase basket.
Okay. All right. Now, and again, given the time limitations, penalty side of this is important. It seems to me that the only evidence that was presented in the penalty phase by the defense in this case was they presented the probable cause affidavit of your client's prior felony conviction, I guess in some way to minimize the state's position, and they wanted to show that it wasn't that big a deal, but it proved that he ran a police officer off the road intentionally. And then they presented the testimony of a jail guard, Sergeant Craig Leslie, I believe, who testified. I guess they put him on to say that he had a pretty good disciplinary record, only had one complaint. But then he also testified that your client had to be asked to be jailed separately because for other prisoners because he might hurt someone.
That's what he said.
I can't imagine that being helpful. So those are the only two things. And the defendant, your client's sister, who testified that he was a good guy, and also did some talk badly about the victim, which obviously wasn't helpful either. So those are the three things that were presented.
The evidence that was presented at the penalty phase by defense counsel was actually more aggravating than it was mitigating. And if you look at Janice Orr, Mr. Pfister was supposed to be the penalty phase guy, but Ms. Orr did the closing argument, and her closing argument, all she did was quarrel with the jury's verdict. And she testified actually at the evidentiary hearing that she thought it might be better if Mr. Simmons received a death penalty because then he could get the services of CCRC and he could get the guaranteed review by this court. So,
well, I'm more concerned. I mean, I'm concerned about that, but I'm more concerned about the availability of mental health testimony that wasn't pursued. Dr. Henry D., a psychologist, would have testified that he reviewed the school records, all kinds of problems there in school,
and
ADHD.
And a PET scan, Your Honor.
And that was done by Dr. Frank Wood.
We hired
the PET scan that showed organic brain damage.
That's correct.
To your client that substantially impaired his ability to think and act logically. And then
you
had
get the two statutory mental health mitigators from Dr. Wood and from Dr. D, Your Honor.
And then you had a psychotherapist who also testified
Hanlon.
During the hearing. None of that was presented during the penalty phase in this case.
No, it was not.
And what was trial counsel's response to that?
Well, again, Ms. Orr said that she thought he might be better off on death row than with a life sentence. And Mr. Pfister said he just felt like a fifth wheel, and he felt like his hands were tied. And he
wanted to plead the case out. He was trying to do that.
He wanted to plead to
life.
Try to get a life sentence.
Now, wasn't Mr. Pfister prepared to give the closing argument, and Ms. Orr wouldn't allow him to do it?
I don't know. It wasn't clear at the evidentiary hearing what happened there, but our understanding was that Mr. Pfister was going to be the penalty phase guy, and Ms. Orr was going to be
in the penalty phase, right?
And what happened was Ms. Orr just stepped in. She quarreled with the verdict, and she said she wished she could have done a better job. And they actually called Mr. Simmons' sister, who came and started to disparage the victim in the case, which was really distasteful.
Counsel, you are now down to a little over 3.5 minutes of your total time, so you're into a rebuttal.
Okay, before I sit down, I would just, because I didn't have time to talk about it, but what we have here on the John Fitzpatrick issue is willful obstruction of justice by the state, and this is the most egregious case of police and prosecutorial misconduct this court ever has seen. And I'll save the rest for rebuttal. Thank you.
May it please the Court, Assistant Attorney General Stephen Ake on behalf of the state of Florida in this case.
Great. Can you just, on this issue of whether the defense counsel, did she have a strategy not to do well in the penalty phase so that this
Your
could
Honor.
Be taken over? What did she say?
The testimony of the evidentiary
Let me just finish
hearing.
my question. It's just going to be better for. What did she say in the evidentiary hearing that could lead someone to believe that might have been her strategy?
Ms. Orr was none too eager to fall on her sword at the evidentiary hearing, Your Honor, and admit her ineffectiveness all over the place. And the trial judge properly didn't factor that into his decision-making, but she testified that when she came onto the case, she hired Jeffrey Pfister because he was qualified. He was going to be the penalty phase attorney. The testimony from Jeffrey Pfister was he was, in fact, the penalty phase attorney. He helped prepare it and was going to present evidence. They had a differing opinion as to what evidence was going to be presented in this case. The client, Mr. Simmons, was the deciding factor on what evidence was presented. Mr. Pfister testified that he had the school records, he had the mental health records, they had a neuropsychologist, Dr. McMahon, that they had retained. They had her evidence. The decision was made to go with a strategy of presenting Mr. Simmons as a good guy because Mr. Simmons and his family did not want to put on any bad evidence before the jury. And that was the testimony.
The good guy evidence, because a lot of times when there's good guy evidence, it actually is good guy evidence. So what was the good guy evidence that the jury heard about this defendant?
That came from the sister, Your Honor. It came from the defendant's sister, that he was a Christian, a very loving person, what have you. Her testimony went to that aspect of it. Again, though, Mr. Pfister testified that he attempted to get details from the family and from the defendant, and they weren't forthcoming with this information. They did not want to present it. He specifically said they didn't want to present any dirty laundry to the jury. They didn't want to present anything that made Mr. Simmons look mentally weak or of a low intellect. That they did not want the jury hearing that information.
Well, one of the things that struck me here is that the public defender, I believe, had the case first.
Almost a year.
And they turned over 3 to 4 boxes of files over to Ms. Orr. And according to her testimony, she only had about a month to prepare this case for trial. And she turned over the penalty phase to Mr.
what's the other lawyer's
Pfister.
name?
Pfister.
Mr. Pfister. So she basically just concentrated on the guilt side of it.
What happened, Your Honor, is the trial was scheduled for about a month after her appointment, but it got continued for, I think, a 6-month period of time, so she actually did have much more time. But
And what did she do in that 6-month period as far as the penalty phase?
as far as the penalty phase, I don't believe that she was doing that much investigation, as Mr. Pfister was primarily the penalty phase attorney.
And what did he do in that 6-month period?
Well, they had the forensic assessment form from the public defender's office, which was this 40-page form that had been filled out, that they had that information. They had Dr. McMahon on board that had been previously appointed from the public defender, had retained Dr. McMahon.
So they met with Dr. McMahon?
Excuse me?
They met with Dr. McMahon?
Yes, and they spoke with her, and she told Janice Orr that basically she wasn't going to have that much helpful information to testify. And again, they made that decision to present her at the Spencer hearing, which they did. They presented her testimony to the judge.
She testified, Ms. Orr testified, though, that apparently Mr. Pfister was intent, pretty much, in trying to convince the defendant, in this case, Mr. Simmons, and the family, to have him plead guilty and get a life sentence. And that didn't sit well with the family. So he didn't have that connection. So, I mean, the picture I'm getting here from reading this record is that we have this one attorney basically throwing everything she's got on the guilt side of it, and was shocked when it was a guilty verdict. Then she's trusting this other attorney to do the penalty side of it, and he seems to be concentrating basically mostly on trying to get the guy to plead. Meanwhile, I mean, there was an evidentiary hearing where all these doctors surfaced. So, I mean, it seems like he didn't do that.
Well, Your Honor, I kind of correct you on some point, is that Janice Orr testified that the reason Pfister didn't have a good relationship was because he wanted this plea. His testimony was he didn't have a great relationship with the family because he wanted them to consider it. He wasn't bent on getting them to enter a plea. He just wanted the family to consider it. They didn't want to listen to that at all, and that, from the outset, that soured his relationship with the family. But he still talked to them, he said. He still talked to the father and to the sister and the mother, but they didn't want to present anything. That's the key here, is that he wrote a memo to his file. The defendant did not want to present anything that would make him look bad to the jury in terms of mental health or any prior family upbringing or anything like that. They also had Dr. McMahon. She didn't come up with anything, really, except that he had a low intelligence in this case. And even in the post-conviction, Dr. D's testimony is not exactly stellar. He relies on the PET scan for his opinion that the statutory mitigators apply in this case, but the state introduced a rebuttal expert on that, which the trial court gave weight to, that basically refuted the PET scan results and said that his brain was totally normal.
Could you address the confession? Was another PET scan done, or his interpretation?
No, his interpretation of Dr. Wood's methodology and conclusions, he said, were wrong, basically.
Well, I thought a PET scan was more objective, that it either is there or it's not there.
Well, Your Honor, what he said was he used basically said the black and white scale that should be used that shows like 256 different degrees of black and white, and that Dr. Wood uses a color scale, which tends to skew the data. And basically his take is really not as bad as Dr. Wood is making it out to be, and is actually quite normal. So they had a difference on methodology on that, and they're both considered experts on it, and I think the trial judge gave weight to the state's expert rather than Dr. Wood's expert in this case. Your Honor asked me, I think, on the confession part.
Yes.
The first issue deals with trial counsel's failure to argue that the statement should have been suppressed based on alleged coercive conduct. First and foremost, the trial judge denied this because there's never been any evidence that Simmons made a quote-unquote false confession. At the very end of this interrogation, after he was confronted, he denied the murder throughout the whole 4-hour interrogation. At the end, when the officers took a break and went down to the Sally Port and saw that blood had been found in his car, they confront him with that information, and then he makes this statement, the single statement, well, if you found blood, I must have done it. That was the one statement that they were concerned with in this case, and even their expert said he didn't know if that was a false confession. So the trial judge in this case said, I listened to Janice Orr, the trial attorney, Her take after talking with Simmons was it was not a confession. It was a sarcastic comment.
Has she actually viewed the videotape?
Oh, yes.
And based on her view, she thought the only issue was that he shouldn't have been arrested, or there was a probable cause to arrest him?
Well, she didn't go into any detail regarding her conversations with the defendant on that. She simply testified that based on those conversations, it was her theory that it was not a false confession, but rather a sarcastic comment. And there's no evidence. They never called the defendant at any time during these proceedings to ever testify that it was, in fact, a false confession. So her strategy was...
I guess my question really is that may have been her view of what was said, but she certainly understood that the state was going to use it as an admission, correct?
Well, they were going to introduce that and argue that.
And so wouldn't it seem logical that she would look at this tape and say, we only got to this point because the police officers used these what some might consider to be intimidating tactics in order to get even to that point. So, I mean, it looks a little strange to me knowing that the state is going to use that confession or that statement as a confession and not explore the possibilities of trying to suppress it because of how they got the statement.
Well, Your Honor, she's the one that actually introduced the entire videotape. She wanted the jury to see the videotape of her client denying this for 2 hours under this interrogation. She wanted to argue to the jury that it was a sarcastic comment. I think that was her strategy, and that's what the trial judge found in this case, is she did not have a basis.
She could have shown that it was a coercive environment and the statement was only the product of coercion, and you wouldn't have to worry about any of that coming in.
Well, you'd have to have a basis to do that, and your basis would have to be you have to think that your client made a false confession that was a result of coercive conduct, which is not the case.
In a Fifth Amendment claim, you have to believe that that it was coerced. You don't have to believe that the client is not guilty of the crime. Am I missing something?
No, you have to believe that your client made the statement as a result of coercion,
right,
which she never believed he did.
Well, but as a lawyer, let's assume that I believe that my client is guilty. I thought that the way the system worked is that you do whatever, as a defense lawyer, you do everything that is ethically permitted to raise claims. I mean, unfortunately, we see a lot of lawyers that raise way too many claims, and we go, please, could you please limit it to the good claims? I'm sort of at a loss for understanding that if you're going to attack and seek to suppress evidence, why you wouldn't use both the Fourth and the Fifth Amendment in presenting it to the trial judge and then ultimately to this court. I've never, said, well, that one isn't as strong as my Fourth Amendment, so I'll just pass on the Fifth Amendment.
Right. She certainly could have made that argument, Your Honor, and that was the whole...
Is her reason, though, what you're saying, her reasonable strategy was she actually wanted all of that evidence to come in?
Well, she did move to suppress it on other grounds.
So she obviously didn't want it to come in.
Our position is, based on her testimony and what the judge found, she did not have a basis to think that this was a coerced confession because she didn't believe that. So she's not going to move to suppress it on that ground.
Let me just read to you one part of the transcript. This is Mr. Perdue, the officer. We're fixing to dissect your apartment. We're fixing to dissect your parents' house. We're going to dissect your car. You got your own friend calling here now, telling me that at 9 o'clock Saturday night he talked to you on your own damn phone, and she's with you at your apartment. You're lying to us. I'm going to send you down the road for first-degree murder, inaudible, lethal injection. The defendant, inaudible, Mr. Perdue. Now, is that what you want? The defendant, inaudible, Mr. Perdue. I don't want to see you die. Enough people have died. The defendant, I ain't killed that lady, man. I don't.
I mean, that's just one piece of it.
And that's the only one, Your Honor, I would submit pretty much. By far, that is the worst statement in this whole interrogation. It comes very early on into the...
Well, my point is, how could a reasonably competent defense counsel have not seen that and argue that in a motion to suppress?
Well, as the judge found, you still have to have a causal connection between the alleged coercive conduct and what actually is the statement. This happens at the very beginning of the interview. This is within the first half hour of the interview. They turned their whole approach around midway through this interview. They went from this confrontational approach to what they called a fatherly approach. And that was a factual basis that the judge said was revealed by the transcript.
So you would say, I mean, this is always that we could decide or may decide that she should have raised it as a reasonably competent defense lawyer, but that a reasonable judge and this court would not find it to be suppressed under the Fifth Amendment, correct?
Right.
That would be the second prong.
Right.
The thing that I find about the counsel, and it was important to me to see the entire performance of counsel, and I know in many cases the state likes to talk about this was the public defender of the circuit, or they tried 20 death penalty cases, and we sort of can take some stock in that when they make decisions that we have some faith in it because of that background. What I'm concerned about in this case is whether this was somebody that wasn't death qualified, and we have reasons for death qualification for lawyers, and yet she essentially did the entire trial, and that the result, obviously it's not just because you get a bad result, but the integrity of the process seems to me to be have been undermined. And so it may be that in the guilt phase, it doesn't infect the guilt phase. But in the penalty phase, I think, to me, we consider her whole performance. Now, what's wrong with, first of all, do you agree that we can look at the way the whole trial was conducted?
I think you can. I think that's what the judge below expressed a problem with, is he said he was in this catch-22 position early on, is that he initially denied Janice Orr's representation because they had the public defender's office and she wasn't qualified. And he says, if I would have stuck with that and denied him the right to have the counsel of his choice, I would have been reversed for interfering with his right to counsel. So when she brought Mr. Pfister on board, he basically had to allow, and they went through a colloquy that, hey, you realize that she's not qualified, right? And
so it was the defendant's choice.
Oh, definitely. Yes, definitely. And he proceeded to listen to Miss Orr. It was clear from both Orr's and Mr. Pfister's testimony that she was running the show with the family and with the defendant.
In terms of the confession, there were two parts. One, what you said was the sarcastic.
Right.
They sort of said this is sarcastic. But what was done about the part that they had consensual sex?
I'm glad you brought that up. Counsel said that the state was arguing that some way proved the murder and kidnapping. That was introduced only to show that he had given a statement that he had had sex with her 2 weeks prior, which was false, because the testimony would have shown that had the semen evidence come in, that they would have testified that it would not have lasted for that long, that basically he was lying to the law enforcement officers. And that's what was argued to the jury as to that. And that's why the stipulation was worded the way it was because it didn't go to the sexual battery that involved anal penetration. It went to the fact that the defendant was lying to the officers about when he had sex with the victim. And again, counsel talks about the neighbors. I want to briefly bring that up. Again, he's missing the fact that the defendant told his attorneys he did not have sex with the victim on that day, and yet he's turning around and saying counsel was ineffective for calling these witnesses that she knew would be lying because he did not have sex with her that day.
What did the evidence, I suppose that was the expert able to say when the semen was likely deposited it.
He said it would not have shown up beyond 5 or 6 days, certainly not in the levels that it was, based on when her body was found. Her body was found, I believe, 24 to 48 hours after the murder.
But it was but I guess what I'm getting to is that there was really no indication that it had to have been done, that the intercourse had to have taken place at or near the time of the murder.
No, there was no argument regarding that as far as what took place there. It was just a violent death with the anal aspect to it, but there was nothing regarding the sexual intercourse. I believe I've exhausted all of the issues that we've talked about. If this court has any further questions, otherwise I would rely on our briefs and ask this court to affirm. Thank you.
The defendant was not on trial for lying to the police. He was on trial for sexual assault, kidnapping, and murder. The jury inferred that because Mr. Simmons' semen was found inside this woman without an innocent explanation, that's why they convicted him. Had the jury heard that this was consensual sex, this case comes into a completely different light. It undermines confidence in the outcome.
And how would they have heard it was consensual sex?
I'm sorry?
How would they have heard that it was consensual sex?
We called, in post-conviction, we called Deborah and Edward Johnson. Their depositions were taken pre-trial. They were not called by Ms. Orr. The Johnsons could have testified. They weren't really friendly with Mr. Simmons. He was just a guy that they saw drink beer all the time. They came to court and they said, we heard loud consensual sex happening right next door to us on the day that she disappeared, was kidnapped, and murdered. Again, this puts it into a completely different light. I want to point this court to...
Wait a minute. Did they put any person with that? They simply said they heard loud consensual sex?
Between their neighbor, Eric Simmons, and the woman known as Deborah Tressler.
Okay.
And, Your Honor, at Strickland at 695, the question here under Strickland is, it's an evaluation of whether there is a reasonable probability that absent the errors, the fact finder would have had a reasonable doubt respecting guilt.
I need to go back to what you just said. So you had you're saying that there were witnesses who could have put Mr. Simmons and the victim as having sex on the day of the murder?
Absolutely. Which would have explained...
And so, which would have explained...
Which would have explained that they had a consensual sexual relationship together, and rather than being completely inculpatory evidence tying him to a murder, this is exculpatory evidence showing that they have nothing but an amicable relationship. There's absolutely no motive for Mr. Simmons to kill this woman.
You don't really have to prove motive, but I mean, it could be taken that we're putting him closer to her on the same day as the murder. If you have a witness who comes in and says, yeah, they had consensual sex that day. And so, I think, I'm just saying, it looks to me like those kind of witnesses could go both ways.
Well, they did not actually see them having sex. They heard two people having sex. They recognized him, but they did not testify that they recognized the woman engaged. That's my recollection of the record.
Well, they know their neighbor is to be Eric Simmons, and then they later knew the murder victim, Deborah Tressler, to be the woman they saw Eric Simmons walking to his apartment with. I have just a few seconds left here. Janice Orr believes in Mr. Simmons' innocence. I believe in his innocence. Janice Orr never thought anything but this was a false confession extracted by law enforcement. Mr. Ake was talking about how this fatherly approach would act to cure the taint of a coerced confession. It absolutely does not. This court issued Brewer in 1980 and said that even PP court and an advisory rights by a judge will not act to cure the taint of prior coercive interrogation tactics employed by law enforcement, just like they were employed in this case. The lower court said that Mr. Simmons was disingenuous because he raised IAC claims. I would submit that if that's the case, Judge Johnson should have recused himself from this post-conviction hearing and not allowed himself to be affected by what he felt were disingenuous claims. Mr. Simmons started out not on a level playing field here.
Was there ever any explanation of the blood in his car?
I'm sorry?
Was there an explanation of the blood in his car?
Well, Yes. Mr. Simmons works in a landscaping business with his father, and there was testimony at the evidentiary hearing that that this woman, the victim, damaged herself on some thorny bushes, and she was always in his car, taking rides and such. And that so there's a reasonable explanation for the semen in the vagina. There's a reasonable explanation for minor blood found in the car, which the judge, even Judge Johnson, said he did not see any blood in this car. The Stuart James, the blood spatter expert, he said, I can't really see blood in the car. So it's not like we have a whole lot of blood, and any minute traces of blood which we have here are explained by the thorny bushes, testimony which should have been presented at trial as well. I would just close with Mr. Simmons never, ever waived his right to effective counsel, and the lower court was wrong to deny our 3851 motion. Thank you.
Thank you both for your arguments. We'll now move to the third and final case on our docket today. State of Florida versus Geis.
May it please the court. My name is Chris Davenport, and I represent the state of Florida. The state seeks...
Let me try to get something straight here at the very outset. The state won in this appeal. Is that correct?
The state won based on good faith.
Okay. But so the judgment that you were seeking to have affirmed was affirmed.
The judgment we were seeking to have reversed was reversed. Yes.
Okay. So the exclusion of the evidence that had taken place was undone. So you left, in terms of this particular defendant, you left the appellate court with total victory.
In terms of this particular defendant, yes.
Okay. Now, why would I be wrong in thinking that you're simply here to ask us for an advisory opinion?
Because the specific holding of the court was, you cannot do this, you cannot get a warrant for blood in a misdemeanor case.
But this got nothing to do with the result in this case. Are you familiar with the concept of standing?
Yes.
How is the state an aggrieved party having standing in this case where you won?
Well, we're an aggrieved party because of the holding of the case.
Because there's something in the case. You have the status of an aggrieved party because the reasoning of the court did not suit you.
We have the status of an aggrieved party because we lost on the legal issue, although we won on the judgment was, the judgment of the trial court was reversed, which is what we are seeking. But we lost on the legal issue, and this is a recurring legal issue.
Well, but it'll come up in some other case, and then when it's really at issue, it can be dealt with.
You're assuming that a police officer is going to go get a warrant, or a judge is going to issue a warrant when he can't under this case law. It can't come up again, because no judge would reasonably issue a warrant in these circumstances when the only law is you can't do that. So it is incapable. We can't get this factual situation to repeat itself now.
You mean there's no way for you to get review if you seek a warrant and it's denied?
No. I can't think of a way that we could get review of that. The warrant would be denied. And no judge is going to issue a warrant now because, even in another district, because the only opinion we have, and that's controlling on all of the trial courts, is the district court's opinion in this case that says you cannot get a warrant in a misdemeanor case under these circumstances.
Well, a county court could certify a question to the appellate court.
They could issue a warrant anyways and certify the question. They're not going to issue a warrant, though, unless they totally ignore the law. It would be, you'd have to assume that a judge is going to ignore the law.
I guess the legislature could amend the statute.
The legislature could amend the statute, yes. But it's our position they don't need to, that the holding of the district court is incorrect. As things stand right now, unless the legislature comes in and acts, we can't get a warrant in these cases, and so we can't get review of this in any other situation.
So you want to talk about the merits, which is, I'm not sure I understand how, if it's a misdemeanor, how you get a warrant when somebody's refused the blood test.
Under the misdemeanor warrant statute, you can get a warrant for property. That's the means to commit the crime.
So we would have to construe what to be property.
Blood would be property. Now, let me say, under the felony...
Well, I'm sure people that give their blood and want to get... I mean, it's not really the common... Is it really the common use of property, blood?
In the sense of... Under the warrant statute, yeah, the warrant. I mean, property is the state would submit should be read as a broad, any tangible item that can be subject to the search. Now,
well, there's certainly support for the proposition that at least with respect to a felony, if blood is evidence with respect to a crime, that would fall within the scope of the property that is relevant to the crime.
Right.
But now the issue here, the district court did not disagree about that. That's not your disagreement with the district court comes in their understanding of the term and with respect to the issuance of warrants in misdemeanor cases.
Yes.
With respect to the property that is it used in the commission of the crime?
It's the means to commit the crime.
The means to commit the crime.
Yes.
Okay. In any understanding of the plain meaning of means to commit a crime, I cannot fathom how blood that is coursing through our veins. I mean, it is, if you're driving a car and you're intoxicated, is the means of committing that crime.
But in this case...
Who is going to understand that blood is the means of committing that crime?
Anybody who understands that it is a strict liability crime to drive with an unlawful blood alcohol level. The only way that you can do that is by having alcohol-infused blood. That's the only way you can do it. Means we would submit is the way that you commit the crime. The way that you commit the crime of DUI, especially in the Duval context, is by having an unlawful blood alcohol level. It has to be the means. There's no other means to do it.
It is such a... we all the time are told that we should not construe statutes or add words to a statute that are clear. And I would, on this one, it is, and I stand corrected on what the issue was for the misdemeanor one. The alcohol is ingesting alcohol. So if there's a search warrant for the alcohol or something, but the blood is again, it's not the means to commit a crime in any plain meaning interpretation. We would look to say that would make us look ridiculous.
The alcohol is the evidence of a crime. It's not a crime to drink and drive. It's a crime to have an unlawful level of alcohol in your blood. That's the way the legislature has defined the crime. It's also a crime to drive while you're impaired. There is a presumption if you have a level of alcohol in your blood, that's how the legislature's defined it, that you're driving while impaired.
I agree that it's defined by the blood alcohol,
right.
And that's why there's an implied consent statute. But it being the means to commit the crime in the ordinary sense of the word, the vehicle is the means to commit the crime.
But it's not a crime to drive.
The blood is not the means to commit the crime. It is evidence that the crime was committed.
Alcohol infused blood is the means to commit the crime as the legislature has defined the crime. Let me take one that seems a little more obvious in ordinary language. It's a crime to transmit HIV intentionally. You use blood as the means to do that if you inject somebody with your blood. Depending on...
If your interpretation of this statute is true, then that means that would result in the police could always get a warrant in any DUI case, and what happens with the part that says a driver can not consent to having his or her blood drawn? That becomes a nullity, correct? Because the police could always get a warrant and come take your blood against your will.
First of all, warrants are a societal good, so we've always encouraged the police to get a warrant. All
that notwithstanding, could the police then in every situation get a warrant to draw your blood, and therefore you would not have any right to not consent to having your blood taken?
If the police wanted to bypass the easier process of getting them applied consent and reading something to the defendant that says, by the way, you've agreed to do this anyways, and if you don't do this, bad things are going to happen to your driver's license. Realistically, a police officer is going to prefer, right.
But now you would have no choice.
Yes.
If we accept your argument, a defendant does not have the choice of saying, okay, you can go on and take my driver's license for 6 months or a year. They no longer have that choice because the police can get a warrant and take their blood anyway.
Every individual who commits a crime has the choice to consent to a search or to be subject to a warrant.
But that question is, then you would no longer have that right if the police can go and get a warrant in every DUI situation, correct?
It in no way changes your right to revoke your implied consent. We're taking it outside the context of consent.
The revoking of the implied consent then really becomes a nullity, however.
Well, that's true if they want to search my car. I can say I'm not consenting. They can go get a warrant.
This is what I'm troubled with. I made a deal with the state of Florida. You give me a driver's license, and if a police officer ever has reason to believe I'm impaired, he has a right to ask me to submit to a breath test.
Right.
And if I say no, you can't have it, the deal's off, the state takes my license away.
Right.
That's the deal.
Yes.
Now, you're telling me that a police officer stops me and says, I want your blood, or I want your breath test. And I say, no. They take my license. But he can get my blood anyway.
He can go to a neutral and detached magistrate.
Well, okay, let's say the magistrate issues a warrant. They can get the blood anyway. It just seems to me there's something wrong with that. You take my license and you take my blood.
This court has always said that consent is one issue and warrant is a different issue.
What Justice LaVarga is saying, which is what makes this not make sense from the legislative interpretation point of view, is you said that I can refuse for them to search my house. Mm-hmm. I don't lose my house if I refuse the consent. But here, the defendant, it's double whammy. I lose my license, and now I'm charged with a crime. I may end up being found not guilty of that crime, but I still lost my license.
But you always lose your license.
Is that correct?
That is correct.
In other words, we have in no other area of the law where somebody, by refusing consent, has a detriment, a huge detriment in this society, not being able to drive. But yet, at the same time, the state has the ability to do the exact same thing, so that no defendant there would be no reason you would essentially be coercing consent in every case, because the defendant may win the case, but they certainly don't want to lose their license. Doesn't that strike you as unfair?
No, because there's no other area of the law where you have impliedly consented to a search like this just by getting a driver's license.
Except that they could have something. The state could have said, when you drive with a license, you are going to consent.
Right.
They could have said that, but they didn't. They really said that the drivers, or every citizen in the state who does not have to consent, there's a penalty if you don't, but you have that right. What you would be saying is the legislature really, and I think that's a policy decision, to say, you know, with all this drunk driving out there, we don't like the way implied consent goes. We're going to just say by getting a driver's license, you must consent. And I might support that policy, but that's not what the law is right now.
But consent is not the same thing as going out and getting a warrant. In warrant cases, you have a judge who comes between the officer and the citizen and says, yeah, under these circumstances, a search would be reasonable. We have probable cause. It's going to be done in a reasonable manner. You have that neutral and detached magistrate coming in. There's a statute that says you can get warrants to search people if you have probable cause to believe that there's a crime, and the Constitution certainly allows it. That's a good thing.
During that time period, is it because they've got to get that warrant within what, an hour, or I mean,
in this case, it was a little under 2 hours. Yeah.
So they've got to get it before the alcohol starts.
Exactly.
Wearing.
Yeah.
And where is the defendant during that?
The defendant is in custody, which he would be in custody anyways, because under the statute, they have to hold him until their blood alcohol level goes down to a certain level, or if they don't have that, then they have to hold him for 8 hours. That's a statutory thing anyways. There's no extra intrusion on the defendant. He's going to be held anyways. The intrusion is the sticking with the needle and withdrawing the blood, but that's all done by a warrant. We want to encourage police officers to get warrants.
Why go through the statutory scheme and in terms of 3.1, 316, 1932 and 33, when it talks about great bodily harm and injury where you probably can do it, but in other where it's not no harm, no accident, I mean no bodily injury. It doesn't allow for that. It seems as if this general statute of the search warrant, you're saying the general should predominate over specific statute? Because if legislature wanted that to happen, they could have put it in implied consent to a statute, couldn't they?
Well, they did put it in complied consent, but only under certain circumstances, not present here. They can coerce, the police, without getting a judicial authorization, under implied consent, can hold you in certain cases and forcibly extract blood. That's not what we have here, though. In this case, we have a warrant. He went outside. It's not just up to the police officer. He went outside. In this case, this has come up in numerous other states. And in the states where the implied consent statute is silent on this issue, every single state that has addressed this has said it's silent, then warrants are something totally outside of consent, so it's completely appropriate.
The legislature has specified in other portions of the statute, for example, manslaughter or serious bodily injury, the legislature actually says in those instances, you can take, police officers, you may take the blood by force, using reasonable force. So they have spoken as to how to do things. They didn't speak in this instance. Why should you be entitled to a warrant here?
They've spoken, here's where you can get blood without any judicial intervention, without anybody else looking at this. The police officers can hold you down and take your blood in these certain circumstances. What they haven't addressed is, well, what about when you go outside of this consent, implied or actual, you go outside of that and you go under a warrant, which is a whole different set of laws. The legislature's silent on that. In the cases in other states where they've addressed this and said you can't do this, the legislature has spoken and said if you refuse these tests, no other tests shall be given. That's when the legislature has come in and said this is the only way. This is the only way we're going to do that. In Florida, they haven't said anything about a warrant. They're completely silent on that. And in other contexts, you can still get blood. If the person actually consents to giving blood, if you're not going under implied consent, you don't read them the warnings, you don't tell them anything about that. If you say, will you consent to give me blood? Nothing throws that out. That's perfectly acceptable because it's a different situation. You're outside of implied consent. In this case, we're outside of implied consent. We're not going under that statute at all. We're going under the warrant statute, which is something completely different.
Which brings us back to the issue of blood being property.
Blood is property. Now, let me say about property. Under the warrant statute, for a felony or for a misdemeanor, you can only get property. So if blood's not property and a misdemeanor...
If we said blood's not property, that would have far-reaching implications.
Huge implications. It would eliminate numerous legitimate law enforcement efforts. You couldn't get blood for a murder. You couldn't get semen in a sexual battery investigation.
Property that is the means for committing the crime. That's what the misdemeanor says.
The means is the one that's specific to misdemeanor. Blood is property. If this court were to hold that blood is not property, that would affect all cases, not just misdemeanor cases. What we're looking at here is whether alcohol-infused blood is the means to commit the offense of driving under the influence.
And how is the felony statute stated as far as the property?
You can get property that's evidence of a crime.
So
it's
wouldn't
more
it
broadly.
be, don't we have that principle that if the legislative body uses different language in two different statutes, and it would be just as easy for the misdemeanor to use that same language, that we should be construing it to mean something different?
Not the word property, but what kind of property you can get.
Absolutely. What I see is a tortured use of means to commit the crime, not the property part.
Well, right. They are
so
clearly
easy
different
for them
things.
to say it. They know how to say it.
And let me say, there are some things that are means but aren't evidence, but are evidence but not means. Like, I would submit an empty liquor bottle in the car would be evidence that you were driving while under the influence of alcohol. It wouldn't be the means to do that. It would be the means for the crime of having an open container in your car, because that's the means. If means has any meaning, and it clearly has some meaning, this is a situation where it has to be the means.
But see, evidence is broader, so it would have included both the bottle and the blood.
Right. And in a felony, you can get all of that.
The idea being that they must have had a meaning that was more narrow than the felony statute.
Right, and I agree that it is more narrow. Now, this is the warrant statute we're talking about. It's not directed just to DUIs. It's directed towards all crimes. I would submit applying that statute in the context of a DUI, the means to commit that offense of driving with an unlawful blood alcohol level has to be the blood. I mean, the blood is coursing through your veins. That's what causes impairment. That's why we have these presumptions. And it's the alcohol-infused blood. Your strict liability for having a certain level of alcohol in your blood.
You have gone over your time totally, but I'll give you a minute for rebuttal.
Thank you.
Good morning.
Good morning. I'm going to ask you a question along the same lines that I asked the state. Now, if I understand your argument, it really has nothing to do with the defendant in this case. Is that correct?
This is an issue of law. Is that what you're asking me?
Well, who are you representing?
Oh, I represent Mr. Geis.
But what's happening here today has no impact on Mr. Geis.
In terms of what the 5th District Court of Appeals ruling was?
Well, I'm talking about in terms of anything except maybe some future offense he commits. But in terms of the offense he was charged with here, this would have no impact on that.
If this court were to address the broader issue of whether or not a search warrant can be used to compel blood in a felony case, it potentially could affect him.
Potentially, but not in this case.
Well,
let me understand. My understanding was in the district court, you lost under Leon.
Yes, sir.
And I also seem to have noticed that you don't make any argument about that to us.
Well, the certified question here was very narrow regarding whether or not...
Well, I understand that, but sometimes we will stray beyond the question certified. But the point is, you have not argued that the district court erred in their conclusion regarding the good faith exception. They concluded that the search warrant should not have been issued, but they concluded that the police relied on it in good faith, and you have not challenged that legal conclusion.
I did not write in my brief regarding Leon. My response to that would be that if this court were to readdress the issue regarding property as being regarding the felony and misdemeanor standard, that we would certainly be able to go back and argue that because what the district court found was that that a search warrant could be issued in cases of a felony.
That's not this case. That's not this case. In this case, I mean, I understand it really was a felony, but at the time the warrant was issued, they didn't know that. The basis for the warrant was the basis for a warrant in a misdemeanor case because of what they knew about his record. So they have to look at it in terms of what they knew at the time. Wouldn't you say that's correct?
Yes, Judge. Yes, sir.
Well, and so at the end of the road here, the district court decided that the warrant should not have been issued. You agree that the warrant should not have been issued?
Yes, sir.
They also decided, however, that the police relied upon the warrant in good faith, and therefore the evidence should not have been suppressed. Now, you don't agree with that, but you have not argued anything about that, have you?
I didn't. You're right. I did not write that specifically in my brief addressing the state's argument regarding. I did not write about Leon. That's correct. I did not. Well,
so your client can get no relief. I don't understand how your client's going to get any relief from what happens here today.
Well,
I don't think the state can either. They want something for some future case. But, I mean, this is like a case with no relief. No one in sight who's going to get relief. Usually we have people who want relief, and they've got a clear idea about the relief they're going to get.
Your Honor, I would argue that this case...
Am I missing something?
No, I would agree that the 5th District Court of Appeal found that Leon, the good faith exception applied in this case. Yes, I would agree. And
you cannot go back and relitigate that. Without having appealed that, is that a final decision? That's the bottom line.
And I guess the short answer to that is I don't know. I don't know if I could readdress that at the lower court level later if this court were to make some... well, and obviously what happened at the 5th District Court of Appeal regarding the misdemeanor issue applies to this case in the sense that it applies to the facts.
But that's the law of the case.
Right.
That's the unchallenged law of the case, it seems to me.
I think it was incumbent upon you to file a cross appeal.
Okay.
Should have.
Well, we sometimes will treat the briefs as essentially a cross notice to invoke. Our rules actually don't provide in these proceedings that aren't appeals for a cross proceeding. But my understanding is we treat the brief in that way. But you've got to present the issue, and here the issue's not been presented.
Okay. In any, going back to the issue regarding means to commit the crime, the state's argument that alcohol-infused blood is the means to commit the crime of DUI, I would argue to the court that the common understanding of the word means would be synonymous with instrumentality, vehicle, agency, and that in this case that the blood cannot be the instrumentality, the vehicle, or the agency to commit the crime of DUI, and that in fact the means to commit the crime of DUI is in fact the vehicle itself.
And doesn't the terminology there imply a purposeful use of something? I mean, and you can maybe argue about how purposeful it has to be, but that someone makes an intentional use of something as opposed to just, breathing and having blood coursing through the veins.
Certainly you don't make a purposeful use of your blood. You don't have a choice of whether or not you use the blood that's coursing through your veins. So that's, and I would agree with that's why blood cannot be the means to commit the crime of DUI.
Well, I wouldn't say you're using blood here in this argument today.
You mean as me personally, the way that I'm using it?
Or that we're using blood to sit up here and judge this. I mean, that's just wrenches the language uses the language in a way that's totally different. I mean, this is your argument, I think. Totally different than it would be commonly understood.
Yes. And
don't we even allow the state to cause a forfeiture of things that are used as the means to commit a crime? So we're going to start forfeiting blood?
That's a whole... yes, sir, I would agree.
I find this, I mean, it's unfortunate. This is the highest court of the state, but this is where this nonsense is leading us to this kind of stuff.
Yes, sir, and the legislature has not interpreted or has not spoken specifically regarding the search warrant statute and whether it can be applied to bodily fluids. And I know that the state argued that there are other courts and other jurisdictions that have applied their search warrant statute to bodily fluids. In my brief, I talked about the Rhode Island statute, which actually was later amended, and they specifically, the legislature in Rhode Island specifically added language to it saying that the search warrant statute could be used for bodily specimens, blood, saliva. And it was interesting to me in researching this case that with all the death penalty cases that come before this court where potentially search warrants may have been issued initially to get blood or other bodily fluids, that no one's ever challenged whether or not blood is property under the meaning of that statute.
But it really, again, there's one issue as to whether bodily fluids become property for the felony, because it's talking about evidence. And a common understanding of evidence is that certainly blood alcohol reading would be evidence. But it is, when it gets to the other statute, I think it stretches it to becoming illogical. I was thinking of what was being said about, well, if you have HIV and you can't transport blood, I don't know, would that mean that if you are HIV positive that the state could just test your blood any time to see if you have HIV? So I wasn't sure I understood that argument. I mean, obviously if you're transporting blood, the illegal act is transporting blood, that would be outside of you. But have you thought of any other, I mean, it does seem to me, though, for your client that there really, you seem to agree that there really isn't any relief that you would get even if we agree with your statutory construction argument.
I haven't conceded that I agree with that. I have conceded that that's something that I didn't argue in my brief, and it may be something that I attempt to readdress later. Whether that's something that I would prevail on, obviously, I don't know at this point. But
I mean, if we held that the warrant, they got a warrant in this case, did they not?
Yes, sir.
And they got blood from your client.
Yes, sir.
And what was the blood alcohol level?
I don't remember off the top
Obviously
of my head.
high enough to get him convicted.
Yes, sir. Yes.
Correct?
Yes.
And if we hold that the warrant was illegally issued, therefore it would render the reading inadmissible, that would help your client, wouldn't it?
Yes, sir. Absolutely.
There will be some relief there, wouldn't it? You should say, no, I'll hear from her in a second. But
it would certainly, it would give some relief to my client, but there are other ways the state can try to get blood evidence in, even if it's
found.
What
about Leon? Yeah. What about Leon? What about the holding of the district court that said which held that the warrant was not valid, but held also that the police relied on it in good faith, and which is an unchallenged holding of that court?
And Your Honor, my response to that has been that that may be something that we have to try and address.
I just don't know, again, and Leon is just not a holding that every search warrant, if it's obtained and they find out it was erroneously obtained, the police get to put it in. And Leon was, I think, a case involving just some kind of a ministerial error. But again, and not to pick on you here, but we cannot address it sua sponte because it's not raised. And so I guess without beating this over and over again, if we keep this case, we've got to make clear we're not addressing that issue. I mean, I may agree, I don't know. I haven't looked at the Leon issue because it wasn't addressed.
I know that Justice Kennedy had suggested this is something that could potentially be treated as a cross appeal. I would argue that
he was saying that if you had put that in the brief, in other words, when the respondent adds issues, we will treat that as we'll treat those issues because you've raised it that way. I don't think he was suggesting that now you could...
I think it's too late.
It is something that I did...
I think correct that you were...
It is something that I argued at the... It is something that was raised at the lower court level at the 5th District Court of Appeal. I would suggest that perhaps the court could consider it because it was raised at the lower court level. That would be my response to that. In any event, back to the issue regarding the search warrant and implied consent, the state has argued that implied consent cannot, or that implied consent and the search warrant statute, they are two completely separate things, that implied consent applies to blood draws that are made without a warrant, and that the search warrant statute can be read in harmony essentially with the issues, or with the statute regarding implied consent. And I would suggest to this court that the issue regarding implied consent and the right to refuse was actually decided by this court back in 1980 in Sam Brine. It's actually something that the legislature's been aware of for 32 years. They've never changed our statute saying that you do not have a right to refuse, and that the defendant in this case did in fact refuse a breath test initially and was taken to the hospital, and blood was forcibly drawn pursuant to a search warrant, and that in using a search warrant that the intent of the legislature in enacting the implied consent statutes was circumvented. The state has argued that, or I would suggest to this court that the specific intent statute, the implied consent statute, controls over the general intent statute, the search warrant statute in this case. And if I could have just one moment. Unless and until the legislature amends the statutes in this case to allow for search warrants and DUIs, the only method by which blood can be drawn in DUI cases is pursuant to the search warrant or to the implied consent statutes when there's death or serious bodily injury, or when somebody appears to the hospital for treatment and the imposition of a breath or urine test is impractical or impossible, or they're incapable of giving consent because they're unconscious. I would ask this court to address the broader question that Judge Torpy posed in his opinion when the question was certified to this court, and address whether or not the prior ruling in Sam Brine that a person has a right to refuse testing controls. I would urge this court to answer that question in the affirmative, and therefore an answer to the second part of that question, which is if the court finds that that it doesn't control, can a search warrant be issued for a misdemeanor? I would suggest that if you answer the first question in the affirmative, that you wouldn't even need to get to the second question. If this court chooses to answer only the question that was certified by the 5th District Court of Appeal, I would ask the court to answer it in the affirmative. Unless there are any other questions? Okay, thank you.
If I could just make 3 quick points. First of all, this defendant is not going to get any relief. He hasn't challenged good faith, nor could he. But this issue is capable of repetition and exceeding review because these police officers want to do this warrant thing. They can't get them now, and there's no way the state can get review of that issue. The state can't say the magistrate didn't issue a warrant and then appeal that. There's no way for the state to get this review any other way.
It doesn't stop a judicial officer from disagreeing with that authority and issuing the warrant, and then come up through the case just like this one.
That officer would be acting completely contrary to the law because they're absolutely
It's not the officer, it is the judicial officer who issues the warrant.
Right, the
so
judicial officer.
So if there's a judicial officer that disagrees with it, I mean, these DUI cases have created a whole world of jurisdictional issues for courts that, in my view, have expanded jurisdiction and cert in other areas. And I mean, the same thing could happen here. There's that a county court judge disagrees, or a judicial officer issues the warrant, and then it goes through the processing, and then you get a circuit court that looks at it, or a DCA looks at it, disagrees, and it comes back up.
And I would say no county court judge can issue a warrant in light of binding authority that says that the warrant
Well, they
statute
do it.
doesn't
Whether they can
apply.
do it or not, my friend, it happens. And we see the cases, so you're incorrect on that.
Okay, and let me say for Duval, I'm not asking for a broad holding about means. Duval is the only statute that I can think of where putting yourself in a certain condition, putting your body in a certain condition, is the means to commit a crime, because that's how the legislature has defined it, as a strict liability crime.
The vehicle isn't the means to commit the crime?
The vehicle is the second part of it. It has two aspects.
Is your brain?
The blood and
I bet your brain.
It's not a crime to have a certain level of electricity in your brain. It's a crime to have a blood alcohol level.
It might be to show, there is PET. I don't know what, the
well, but that's
blood is.
No statute defines brain activity as a crime. There's a statute defining blood alcohol level as a crime if you drive too. So that is, and just to clarify, the HIV, my intent was it's a crime to knowingly transmit HIV. So if you took a vial of your blood and injected it in somebody, that blood can be a means under certain.
Your blood out.
Right, or transmit it directly somehow. But be that as it may, we'd ask you to reverse that aspect.
But there is a distinction between taking the blood out and using it in a certain way,
right,
and having the blood coursing through your body, and saying that that's being used.
And in these limited circumstances, the legislature has defined that blood coursing through your body as being a crime. So that makes it the means.
How about if there was attempted sexual battery but didn't occur, and they wanted to search your blood to see if you were HIV positive in order to show that you had HIV?
I don't see where that would be the means to do anything.
Attempted murder.
Thank you.
All right, we thank you both. That is the last case on today's docket. Court is now adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.